The stepchildren complicate your probate case. If you're the surviving spouse and you're contemplating filing a petition with the probate court to be the executor over the estate or the personal representative over the estate, there are a few things that you should consider. First, you want to make sure that any property that you owned with your now deceased spouse was not held as joint tenants with rights of survivorship. If it was, then that property will pass to you by operational law and will not be under the jurisdiction of the probate court. You also want to check any joint bank accounts or any bank accounts that your spouse had solely in their name to see if you're the beneficiary or named as the POD, payable on death, recipient under that account. You also need to check any other beneficiary accounts such as 401ks or any investment accounts with stocks or bonds. Usually those are set up where there's a beneficiary. So you want to isolate that property that is solely yours and solely accessible to you immediately so that you can gain access to that property. And the same goes for any vehicles as well. If you both had those vehicles in your name, then you should be able to go to the tag office, transfer title, and then you would be the sole owner of that property. As far as the actual probate of the estate, the things you need to consider first is whether or not there's a will. Your spouse likely had documents or financial records held in a certain place in the house, and maybe you know of the will and maybe you don't, but you want to check to make sure whether or not there's a will. If the will names you as the executor, then you want to prepare yourself to proceed forward with filing a petition with the probate court to be officially named as the executor. If someone else is nominated as the executor, then it's advisable for you to make a copy of the will and then get that original will to that person who's named as the executor so that they can follow the steps that's required by law as far as filing a will with the probate court. In those situations where there is no will, then you can file with the probate court to be named the administrator over the estate. Georgia law has a pecking order for who should be named the administrator of an estate, and the first person is the spouse. So you're the highest ranking person out of the heirs, and preferable under Georgia law as being the administrator of the estate. If you are planning to file for a petition for letters of administration, it's always advisable to reach out to the other heirs and let them know what's going on. I think the heirs would appreciate the openness, and they would feel a lot better if the process is being started and they're being informed and kept in the loop about what's going on. Otherwise, when you file and folks are just being served by the sheriff, and that's how they're finding out about the probate, it feels like things are trying to be done behind their back, and you're much more likely to have an objection filed against you or petition, which causes the process to linger on for months and likely into the following year as well. Sometimes as the spouse, you may be in that situation where you find out that a stepchild has filed with the court to be the administrator of the estate. In that situation, you'll have several options, and one includes filing an objection. You can file a caveat with the court, asking them to instead appoint you as the administrator of the estate. You would also have to file your own competing petition for the court to have the authority to actually name you as the administrator. The problem in those situations is that usually when two heirs are competing to be the administrator, a lot of the courts would just appoint the neutral third party, the county administrator, to be over the estate. And there's a fee associated with that. The county administrator gets 5% of the estate value, and a lot of the county administrators are just busy. They have heavy caseload, so communication and information from the county administrator is not always free flowing. So you may find yourself in the dark, not knowing what's going on and just waiting for the estate to be administered at the pace set by the county administrator. So we always look for solutions where we can try to avoid having the county administrator appointed. As the spouse, you do have a secret weapon. And that secret weapon is called a petition for a year's support. This petition can be filed whether there's a will or, and certainly in instances where there's not a will. So if your spouse has a will leaving all of her property to your stepchildren, then you can file a petition for a year's support, and you can ask the court to set aside a portion of the estate or to give you the entire house out of the estate as support so you can continue to live the lifestyle that you lived during the time that your spouse was alive. So it's a very powerful tool, and even to the extent that when the petition is filed, a lot of times it increases the chances and likelihood that the other party will enter into a settlement with you. So once you decide on how you want to divide the property up, the spouse gets what's allotted to them under Georgia law, which would be no less than 1/3. The other 2/3 goes to the stepchildren, or if it's just one stepchild, then it would be 50-50. If you reach that type of agreement, you still can have it where the court awards the property under the year's support. And that means that the spouse gets access to that property immediately and can sell the property and split the proceeds, however the parties have agreed. But the point is that year support is a great tool because it does help to avoid some of the delays with that you would see in the regular probate process, which would be being named the administrator, having creditor notice run in the newspaper, giving creditors 4 months or so to respond, dispersing money, and then to the creditors, and at the end, dispersing the money to the beneficiary. So again, year support would act to avoid all of those additional time delays that you would see with a traditional probate matter. So again, when we have a situation with a step parent and with stepchildren, often there is a lot of conflict. From my experience, what I see is the spouse is older and has now lost his or her spouse and looking ahead through life and the possibility of being alone and having to try to navigate this. And there's years and years of history with the spouse, and that person feels more entitled to the assets than the stepchildren. And then the converse is usually true as well. The stepchildren feel as though I just lost my parent, and therefore I'm the primary heir and I'm more entitled to the assets than his or her spouse. So we just going into the situation, we understand that. And so whether we're representing a stepchild or a step parent, we can look down the road a bit and we understand how this process is going to go. We understand the emotions, and we start immediately looking for different ways where the parties can reach an agreement and avoid unnecessary legal costs and unnecessary delays. The stepchild is important for the step parent stepchild relationship to have more collaborative approach to the situation. Otherwise, you'll end up in probate court fighting it out, waiting a year, 18 months to get in front of a judge who doesn't know you, doesn't know your spouse, doesn't know your family, making a decision on your inheritance or your stepchild's inheritance. And at the end of the day, that just doesn't feel good, just having this stranger having that level of involvement on something as personal as your loved one's estates and assets.